You're listening to Radio Cayman, your official radio station. It's 2 minutes past the hour of 7 o'clock. At this time, For the Health of It, normally heard on Wednesday evening at 7 p.m., will not be heard tonight here on Radio Cayman. Instead, we have a time delay of the Immigration Town Hall meeting taking place at the Mary Miller Hall in Red Bay. It concerns the Immigration Transition Amendment and Validation Bill 2025. And once again, this is coming from the Mary Miller Hall in Red Bay.
We are here to discuss the Immigration Transition and Amendment and Validation Bill 2025. My name is Jevy Ebanks, and it's my pleasure to moderate this evening's town hall. The purpose of tonight is to provide a consultation period so that the government can provide transparency and encourage engagement and ensure that the perspective of Caymanians, residents, industry representatives, and other interested parties are considered before the bill is finalized. So thank you so much for joining us this evening and being a part of that conversation. Throughout tonight, we hope to get feedback on the objectives and the provisions outlined in the bill, including matters relating to Caymanian status, permanent residency, residency and employment rights certificates, work permit requirements, financial standing, and compliance measures. Our panelists are inviting you to issue comments that may address the policy intent, practical implications, and other relevant considerations. Before we go ahead with the presentations tonight, I just want to say that we are currently operating on a 2 questions per person standard for this evening. So whether you choose to use that as 2 individual questions or a question and a follow-up, we ask that you be mindful that there may be others who want to have questions answered as well. Also, just in case you're asking questions that contain very specific or personal information, we ask you to be mindful that this is being broadcast to the general public, and so you should take extreme care in saying personal information publicly. There are ways for you to ask those questions this evening, for you to either jot it down on a piece of paper, and we'd be happy to provide it to the relevant person who it's addressed. Of course, we also have other government representatives who are sat over here to the front who may be able to speak to you one-on-one and get those questions answered. So, with that being said, if you have other responses beyond tonight's conversation that you want included in the consideration of this bill, we ask that you send all responses via email before the close of business on the 14th of November 2025 at immigrationconsultation@gov.ky. For those joining us via social media, we do have teams monitoring social media, so please feel free to share your questions there as well, and we'll ensure to answer them. Our panel includes the Minister of Caymanian Employment and Immigration and the Member of Parliament for Prospect, the Honorable Michael Miles, as well as Chief Officer in the Ministry of Caymanian Employment and Immigration, Mr. Wesley Howell. Also on the stage is Senior Policy Advisor, Ms. Rolna DaCosta. Please welcome them to the stage. At this time, I invite the Minister to give his opening address.
Good evening, everyone. I do better standing up, so indulge me. I want to apologize ahead of time, just struggling, trying to recover from a cough. So if I'm coughing a little too much, I'm going to take a break, but I think I can get through this for the next hour and change. First of all, I want to thank everyone for coming out tonight and certainly supporting this town hall, but also providing your support with questions and certainly clarifications and so forth. We want to make sure that everyone gets this, that all of our people understand our immigration reform. It's not this big, scary monster. It is pretty straightforward, and we're hoping and praying that everyone gets this. And if you don't, please give me a call. I'll organize another meeting for you, and we can certainly discuss this. Before I get into it as well, please keep Jamaica and Cuba in your thoughts and prayers. I'm sure that everyone has seen, just to share destruction that have gone on in that country over the last 24 to 48 hours. I'm sure that folks have, if it's not some of you, I'm sure that you know some folks who have people or family that lives in that country. As much as you can, please continue to reach out. We have a team, the premier, the governor is going down. It's going to be taking some much needed supplies to them, to the government over there tomorrow morning. So please keep our team in your prayers, because I know the wind and rain and all of that is still in our vicinity. I wanted to get into this because I also want to make sure that everyone, certainly in the listening public, also understands that we've been doing public consultation for the last month or the last 5 or 6 weeks now, and it's been glorious. It's been great. We've gotten a lot of wonderful feedback. We've probably met with at least 80 companies. We've met with just about every sector, from tourism to the financial services, to construction, human resources. I mean, everyone has been at the table, and they've been really great in giving us feedback. Between myself and my chief officer, Mr. Howell, who's really the specialist in this, Mr. Howell is going to give you a lot of the technical overview. What I want to provide tonight is how this have all come about in the last 6 months. And to also share with you, that this was not just about, just wanting to change the immigration laws or regulations. This was, what problems are we going to solve? How can we be thoughtful about this and not have a knee-jerk reaction? So tonight I want to give you some background, and I'm going to go through the policy intent. Mr. West is going to go through the proposed bill, next steps, and then we're going to get some question feedback. As Mr. Jevy said, if we can limit it to 2 questions so we can get everyone to get their questions answered as well, and I know that we're going to be collecting questions from our online viewers, that would be appreciated. I want to share this statistic with you, because this is one of the things that, as we campaigned over the last year, this is one of the things that we started to look at when we looked at immigration reform. And these are relevant statistics to this. Currently, one of the biggest challenges that we have in our WORC, which is work department, is the amount of temporary work permits that we're processing. Currently, we have about 65,000 applications that come through WORC every year. It's about 65,000 on average. Of that 65,000, 40,000 of that are temp work permits. Out of that 40,000, 30,000 convert to full work permits. Now, here's what that means. There's a delay in us actually getting to full work permits. 99% of the organizations that are applying for a work permit want a full work permit, but because we can't seem to get that under 30 days, they're applying for a temp. Now, I want you to imagine this. We have 30,000 of those temps that are converting. The immigration department is touching all of those work permits at least 3 times. The first time, to get the person in the country, we touch that work permit. Then, most companies are also using us to regulate their probationary periods, because then they extend it to another 3 months. And then once that 3 months, once that extension is over, they're now applying for a 1 year or a full work permit. It puts an enormous pressure on our immigration department that we are not efficient. We have to get back to where we're efficient. Temporary work permits were actually meant to be 1 to 3 months. That person comes in for a temporary period of time and leaves. A doctor comes in to do a procedure for a couple of weeks or even a month or two and leaves. An attorney comes in to work a case and leaves. A person, a band or a musician comes in for 1 to 5 days to do a couple of gigs and leave. That's what temporary work permits were made for. Successive governments have allowed temporary work permits to actually be really everything because it's driving revenue. Immigration can no longer be about just revenue. Immigration must be about protecting Caymanians and protecting our borders. So our organization, our coalition have decided we need to change the focus of immigration. And that focus have to be with us reducing temporary work permits. And Mr. West will go into some details of that. Now here's what it drives. Because over the last decade or so, there's been significant silos within the government. Our government, your government, over probably the last 3 to 5 years, spends about $40 million a year on scholarships. And because we don't actually share information, I don't know who's overseas. I have no clue. Currently, based on the numbers that I have seen, we have over 1,800 young people in some sort of tertiary education school. Now, here's what it does for the numbers, because I don't know, Mr. West doesn't know, and our work department doesn't know. It's driving more work permits because the business community needs talent. Just this year, we have just in the fall semester, we've approved $20 million. That have put over 1,180 students in an overseas placement. The only student that I know that's overseas right now from the fall semester is my daughter, Haley, who is doing her master's. So what Minister Anglin and I have decided is that silo needs to be kicked down and kicked down fast. I have to have a clear understanding what the labor market is and what we need to do to prepare for all of our young people to come home and get jobs. Because what is happening, I'm getting calls from children, young people all over the world saying, am I going to have a job when I finish this degree? I have grandparents calling me, parents calling me, young people calling me, friends of friends calling me saying, Minister, are we going to be able to work? We have to get temporary work permits under control, and we have to ensure that the talent that we want is fast-tracked straight to a full work permit. Hence, we need to be more efficient. As long as we're processing 40,000 temps a year, immigration is going to be in the same state that it has always been, chaos. And we can't do that anymore. Our government is prepared to move immigration to a next level. And it has to be where it makes sense, in particular for our people. Now, there's another 2 stats that I also want to share with you that's affecting a lot of the expenditure within the Cayman Islands government. And it's what we found. Now, I've known this for a long time, but the public doesn't have an appreciation for the mass levels of expenditure. Where it says the Department of Financial Assistance, we spend now, and this is the Department of Financial Assistance was recently rebranded. It also came from the Needs Assessment Unit, so it was rebranded to the department. We're spending approximately $60 million on aid. We have a lot of able-bodied people that are receiving aid. And a lot of it is because we have a lot of cheap labor coming in. Therefore, it's shrinking the labor market. It's not sustainable for us as a country. We have to be able to change this, and we have to change it now. So yes, immigration may make $100 million a year, but we're spending $60 million a year on that, on welfare. So we can have, on any given day, a 20-year-old, 25-year-old that's able-bodied, can't get a job in their country, walk into the Department of Financial Assistance, and we are having to support that young person. We can't do this long term. So a lot of the reforms are coming based on us. We have to be able to fix significant problems that is within our country. The last stat that I want to share with you is this stat that we continue to grapple over as a government. We spend approximately $75 million a year on indigent health insurance. When our people can't get jobs and they can't afford health care, you, the government, me, the government, we have to support them. We provide that to them. What is also unfortunate as well is that out of that $75 million, $10 million of that goes to the expat community who also can't provide or support their own health care. We can't sustain this long term. When we look at immigration reform, we want it to be thoughtful about it. We have to look at the numbers. And these are the numbers that jump out to us. Our children, we're spending the money, they're educated, they are driven to be successful, they come back to our country, and they can't get employment. We have to now start to look at where we're going wrong. So what we've done is take the politics off the table. Let's start talking facts. This statistic here is also what we've worked on. We have to make immigration efficient. Therefore, our immigration boards process less than 15% of the 65,000 work permits. So over the last 6 months, I've visited the boards, talked to board members, I've sat in on boards to see what the operation is, and after 6 months, I've decided the boards aren't efficient. We have to make the boards more efficient because our administrators, who are also part of our boards, are very efficient. But our boards are also taking a lot of administrators out of immigration, so it makes our administration less efficient as well. How do we expedite that? We have to make sure that the boards are better, and we have to ensure that the boards are non-political. Now, part of this process, you would think that it's common sense. It's not. What we've done from successive governments, we play politics with it. I have no interest in playing politics with immigration or any other department that falls under Caymanian employment. Our coalition has made it very clear. We have to now look at how do we get Caymanians back to work? How do we ensure that Caymanians are moving up? Because we have to make sure that Caymanians can support themselves, pay for health care, make sure that they can thrive in the economy that we have built, that our grandparents have built, that our seafarers have built. This, in a nutshell, is why we're driving the reforms. It has to happen at this point. Now, I want you to look at the landscape of another major state that have also ensured that we're driving reform. Between 2015 and 2025, 9,084 individuals were granted permanent residence. We all know what leads after permanent residence. You have status. Some say it's too much, some say it's not enough. Caymanians are feeling overwhelmed. I'm going to go with what Caymanians are telling me. I'm feeling that that this is no longer my country. So we have to ensure that Caymanians are protected. Out of that, 2,971 individuals qualified through the point system, 4,000 qualified from marriages of Caymanians. Now here's another problem that this have increased. So we now have, and I'm sure that this is no surprise to you because everyone in this room have probably heard it, is a lot of sham marriages. We're being inundated with it. The Immigration Department is currently investigating at least 200 plus sham marriages. Now, I cannot give them the personnel to do more. The reforms have to be able to manage some of this. We have to arm our boards. We have to arm the director of immigration in order to ensure that we can do this better. Now, I can only tell you some of the mess that I have found. Every government that I've got in, they've kicked the can down the road. What I've said to the coalition, if we're going to do immigration reform, we need to do it properly, and it need to be based on facts. We can't do immigration reform based on feelings or based on, I don't like this person. It has to also be consistent. You can't do immigration reform just for the public sector or just the private sector. So one of the first changes that we made in our immigration reform was forcing the public service to put in term limits. Because you can't have a public service that is gazetting laws, creating laws, establishing laws, but don't follow their own laws. So the public service have to be part of the reform, and now they are. We also have to have successive training within the civil service. You can't have an individual that jumps from the private sector after 6 or 7 years knowing that they're going to go into rollover, come into the civil service, spend another 5 years, fast track them through PR, and then they're on to citizenship, leave the civil service, go back into the private sector, and now they are full-blown Caymanians. We no longer can tolerate that. Now, some people say, Michael, I disagree with you. And I can respect that. My goal is to protect 40,000 Caymanians. I have nothing against the foreign contingency. They've helped us build our country. But my goal and the government's goal is to protect the 40,000 Caymanians in our country to ensure that as citizens, we feel that we have a say. Now, I just want you to just have a look at what this is. When I saw this slide, it is scary. Now imagine saying to every child at John Gray, Clifton Hunter, CIFEC, CIS, Prep, Catholic, all of the high schools that not only are you not going to have less of a future, but we're going to give you more and more competition to compete with. They already have 8 billion people to compete against. We're piling up on this. Now, again, we have to leave the politics off the table. We have to start to look at the people. Are our people in a better situation than we were 10 years ago? The country's improved. We've built a lot of stuff. We have a lot of shiny new toys, built a lot of buildings. But the people ourselves haven't moved. And I'm having to deal with those calls every single day, many times a day, of people very concerned that them or their children are not living the life that we as Caymanians, we as the government is saying that they should live. When I have folks that are 25 years old that are on subsidy from the Cayman Islands government because they can't pay their rent. When I have a young person that have contacted me after applying for 100 jobs and they're all entry-level and cannot get a job. And I amplify that by 100 times. We have 1,000 young people that are saying, is this working for us? I have to look at the stats and say, it's not working for us. How do we then make it work for us? We have to be thoughtful about the laws, so we've decided that we have to be able to do something different, but something balanced. And as I said to a lot of folks, a lot of focus groups that we have done this presentation with, our goal isn't to cripple the financial services industry, the tourism industry. We want those industries. We certainly want those industries to also prioritize Caymanians. And for a very long time, they're not. And we have to get back to that. I am not under any illusion that we are going to fill every job in the Cayman Islands with Caymanians. We have more jobs than we have people. But I am here to say, and I've said it to a lot of employers, big and small, if you don't hire our people, you're not hiring anybody. It's as simple as that. Without reform, we're being squeezed. Without reform, the sectors are being overwhelmed. I've showed you the numbers. I've shown you two figures, just social services, and I've also showed you what we're looking at just in healthcare. And that doesn't include government employees. That's just indigent care. The police department is about $70 million. I can rattle figures off to you on what we're paying of organizations that don't pay back. Those are just services because of population explosion that we're now having to deal with. Now, like I've said to a lot of folks, we want, we need, we appreciate the private sector. They are a major contributor in the Cayman Islands government. But this has to be a partnership, a collaboration. It can't just be a free-for-all. You can't build a hotel and say, well, I'm not going to hire your people. You can't put down a bank and say, well, I'm going to bring in my own GM when we have, a person that's qualified for those types of jobs. See, no one don't have to tell me about what goes on here. I've seen it. I've sat in, I've talked to the experts, I've sat in with employers. I've seen the negotiations that have gone on with previous governments. People make promises. Well, yes, I'm going to, hire X amount of people, and then when we give them a concession, those people aren't hired. We're overwhelming this infrastructure, and then we're turning around and saying to our people, I'll just give you more welfare. It's unsustainable. We know what goes on our roads. Everyone, I'm sure, in this room has some level of bumper-to-bumper traffic. We also know what is happening to our housing market. I don't expect a 21, 22-year-old that has just got out of high school or just got out of university to be able to afford, a house. But I do believe that it has to be possible. It has to be possible, and right now it's not. It's out of reach. The average young person do not see that it's possible for them to own a house or purchase land in our own country. So what do? Do we sit back and continue to make promises to you? Or do we make the changes that are common sense, that are balanced, that ensures that we protect the vibrant private sector, but we prioritize our people? This is where we're going. One of the biggest fears that I often hear, and I've heard over the last 6 months, more in my face, but I've heard it, probably over the last 8 years or so, in particular from young people, is that I don't feel that I'm Caymanian anymore. I don't feel that I go into stores and they don't talk my language. I go to interviews and I have to ask for clarification because I can't understand who they are. Or I want a promotion, but my supervisor seems to be leaning towards the other people that come from that person's culture. This is what they're saying. Our identity is being lost. Do we listen or do we play politics? What the coalition have decided is that we're going to listen. But we're not just going to listen for the sake of listening. We're now going to act. We're going to do something about it that's going to be thoughtful. Like I've told the private sector, I don't know what's going to happen in the next 4 years, 8 years. I do know that the current laws, the current structure that we've put in place, I believe that's going to serve us well. I also believe that if there are significant changes or any changes at all need to be made, that I believe that we have a competent government that's going to come back to the table and say, something, this isn't working for us. Let's change it because it's not working. Or, it's a consequence that we didn't see coming. Now, I will also say to you, after the last 6 weeks of a lot of focus groups, talking to a lot of experts, a lot of lawyers, a lot of folks from the accounting firms, there's not a lot of people that are able to put holes in what we've designed because they've been a part of it. They've suggested a lot of these reforms. The ministry has a vision, and our vision is to be empowered. It's a resilient Caymanians. We're empowered Caymanians, and a balanced workforce strategies, support a prosperous community, and delivering sustainable growth. Every time I share this slide, I often say to folks, we have to have sustainable growth for everyone. We can't have sustainable growth for just a handful or just a few. It has to be across the board. We also have to have workforce strategies. I've also said to everyone since I got in this position, I am not doing immigration reform for 4 years. I don't think it needs to do 4 years. Immigration reform can be done in less than 2. In less than 6 months, we've put good immigration reform on the table. But our goal is to make sure that it's sustainable. Our goal is also to ensure that there's a strategy for employment, that we're not just kicking that can down the road. So what our ministry have become is about employment. How do we ensure that young people know what is out there? When does AI take off? When do we start to create those jobs? Our mission is to deliver people-centered focus. How do we deliver that? We have to start to listen to you, the voter. We have to start to have a clear understanding what it is that you want and do what you want. You don't need more buildings. You need us to now focus on ensuring that you have a future. And that future can't be every 4 years. It has to be 10, 12, 15, 20 years. That your children, grandchildren, and great-grandchildren deserve some level of hope. So therefore, what I have done, my customer is the 40,000 Caymanians. My organization is looking at 40,000 people. How do we keep you happy? How do we ensure that everything we do is something that you know that you want? And we're not going to give you all your hopes and dreams, but the opportunities are there. How we look at the services of Cayman to enhance the workforce skills and promote economic well-being. I say to a number of folks all the time, what is well-being? How do we focus on that more? How do we ensure that people have a clear understanding when I start high school or primary school and I have a vision of where I want to be? How do we make that a reality? Well, we're spending the money. We're spending $40 million a year on it, and that's just the public sector. I'm sure the private sector is spending probably another 10 or 15. How do we make it a reality that people have economic well-being? That's what this bill is about. It's about promoting that. We foster strong partnerships. I said to the private sector, this is about collaboration. This is about them. This is about them coming to the table and being reasonable and being honest. Because they're making a lot of money. I'm not here to take money off the table. I'm simply here to say our people need to thrive, not survive this. We need to thrive in it as well. And you can't judge one person and say, well, because of one person, 40,000 is lazy or can't do this. And that's what I'm hearing a lot more. We foster strong relationships and facilitate information. Our government have decided that we have to start to share information. Minister Anglin and I, we sat down and we've said we cannot have an embargo between our ministries. I need to know every child who are overseas. Because prior to them coming back, and I don't mean a couple of months before, I mean 4 years before, I need to know who they are. We need to start to prepare for them. We need to put in viable programs. We need to connect them to services, whether it's in the public sector or private sector, that when they come back, they have an internship, they have an apprenticeship, they have employment. We have to start to prepare. But if I don't know who they are, if I don't know how many accountants are provided with scholarships, how do I say to a KPMG, hey, we have 10 young people coming back? We have to know who's out there. And we need to know that immediately as they're granted a scholarship, that information is shared with us. Sharing while ensuring compliance with immigration, labor, and pension. One of the major things that we've now connected is that we've also connected, in particular, our departments. Labor and pension are underneath the Ministry of Caymanian Employment. When we designed immigration law, we started looking at the labor laws. We started looking at the pension laws. We needed to make sure that it wasn't going to adversarially affect any of those laws. All of these things have to be done. We're meeting with DCI because some of the things of what we're doing impact them. HSA, the Health Insurance Commission, the police department. We're breaking walls down. We're forging relationships. Part of this bill is forcing government departments to now communicate with each other because it's not our strongest point. So we now have to be deliberate about this because if we're not, we can change all the laws of what we want, but if people aren't coming to the table and sharing information, it will never work. I'm going to hand it over to Mr. West. Thank you guys. I appreciate you guys coming again. Enjoy the rest of this presentation.
Good afternoon, good evening. So I am going to sit for the time being. The policy intent really is what Minister Mars just laid out, but to put it in straight words, it's the intentions of the reform is to update and refine aspects of the existing legislative framework and to be responsive to some of the social and economic circumstances that we find ourselves in, and Minister Mars did a great job outlining what those are before this. So I'll go right into the changes in legislation. Right up front, I'll say if you came tonight looking for information on changes to the PR point system and term limits, that's not part of this piece of legislation, but I can assure you that that piece of work, we've been tasked to do that, and that is soon behind. The approach that Minister Mars wanted to take was not to wait on a comprehensive bill and take a year and a half, 2 years to do it. We have bits that are ready to go now, and we took those bits forward with the other bits coming in the next round of changes. First up and foremost is the change of the principal law. This is the base law. The Immigration Transition Act is going to be renamed to the Cayman Protection Act. And we were on Mr. Connor's show, I think it was last Friday, and he reminded me that that was the law when he was last Chief Immigration Officer in 2003. That was the name of the legislation. The changes to work permit are coming up next, and one of the issues that is a burning issue, part of this relates to the multitude of temporary work permits, but if you follow immigration in the media, you will see that they are, actually I didn't even check the courts today to see what the sentence was for the individual who was caught facilitating work permits of convenience for individuals from a particular sector, from a particular country. But that is an issue for us. We know, and Cayman is not unique, that we have individuals from the Philippines, from Nepal, who are being exploited quite significantly. Some of them are working with local actors in order to get work permits for them. They usually come in on a temporary work permit, and during that period, they look for legitimate work. So we put in some issues, some controls around that particular issue. So within the first 2 years of their employment, an employee would not be able to change employers save for prescribed circumstances. These are exceptional circumstances where they're not being paid, they're being abused, and so on. We don't want to lock them into a bad employer or employee situation, but we really want to shut down the jumping from one position to the next. The other group of individuals who have made significant representation to us are small, medium businesses who are typically the ones flying individuals in from around the region, in some cases around the world, paying their settling expenses and so on, and they then shop around when they're here, cancel their own work permits and go and apply for one for an employer who's paying a bit more down the road. So employers who are out of pocket for that settling cost are ones that are asking for some relief in relation to this. So this strengthens the provisions that are there now in relation to job hopping. The second one is in relation to marriages of convenience amongst work permit holders. So it's not just marriages of convenience amongst persons with PR and persons with who are Caymanian. The scenario here with the marriages of convenience among work permit holders is if I'm here on work permit and I'm approaching my term limit, so I'm at like year 7, year 8, I'm fairly certain I'm not going to be able to qualify for permanent residency, but I want to continue working longer than that. Then I enter into a marriage of convenience with someone whose work permit is on year 1 or year 2. I can then piggyback as their spouse on a spouse of a work permit holder exemption and carry on for an additional 6 or 7 years past my term limit. So this provision that we were introducing here, if you're going to file married, then the limit would be that of the lower, not of the higher. So you don't get to have an additional number of years added on for that convenience. Changes in relation to PR and RERC. You would have seen the statistic, the graphic with the number of persons that became Caymanian, and the vast majority of those are through marriage. So in 2024, there were 669 marriages, including approximately 150 visitors who got married in the Cayman Islands. And I just checked with the acting director and her team here, are investigating well over 200 marriages of convenience. So the numbers are actually quite high. So hence the reason why we are pushing out some of the timelines as it relates to RERC and as it relates to Cayman status coming later on. So what this does is, in relation to persons holding RERC, so currently the permanent residency certificates that are issued without an end date, so they're indefinite. Because they're indefinite, that individual within a year of receiving that document could go and get naturalized. So if we're starting a work permit at year 1, persons can apply for permanent residency at year 8. If they're granted permanent residency in year 9, by year 10 they're naturalized. They then have to wait an additional 5 years to get to the point of 15 years in the islands and be naturalized in order to qualify for the right to be Caymanian. This pushes that out to 15 years instead of the current effectively 1 year that it is now. So in practice, what this means is an individual would have to have their PR facility and be in country up to 9 years, up to 15 years, sorry, at which time they would apply for PR. Again, the document that they would get at that point would be a PR open-ended. So they've already been in country for 15 years. If they're granted PR again at that point, then that is PR without an end date, which then allows them to transition over to be naturalized, and then they could apply for the right to be Caymanian through that. So I will quickly add that there is a school of thought that no one should be applying for right to be Caymanian through naturalization. The drafting, the policy directives that we have and that we've drafted, we were not told to write the laws in such a way to prevent individuals from progressing through under the point system and through onto PR. This simply lengthens the runway and limits, again, sort of who can qualify for a BOTC Cayman Islands passport before they could effectively qualify for the right to be Caymanian. So progressing on, continuation of RERC for the children of Caymanians. So this delves into the aspect of individuals whose marriage to a Caymanian or a PR holder has fallen away and or is no longer intact, and they have a child of that union, and they've applied for continuation on the basis that they have that child, a Caymanian child, and this is, in some cases, we've seen, there's a bit of feedback. In some cases, we've seen where individuals who have effectively, they're DNA donors and haven't had any connection with the child, but when the marriage falls apart, they realize that this is a bit of a loophole that they could exploit, and will file for a continuation on the basis that they have a Caymanian child. These provisions seek to ensure that they are indeed a part of the child's life in a positive way, and the legislation does provide for our government agencies, be that DCFS, DCR, or the courts, the courts, to provide information to ensure that that relationship is a legitimate one and is in the best interest of the Caymanian child. If an application is, if an individual isn't meeting their application, their parental requirements, i.e., in some cases where the divorce has happened, there's a court order that the spouse has to pay a certain amount of child support and so on. As drafted, there's a 6-month window for which they can rectify those issues before following on for the revocation process to start. Applicants must also demonstrate good character and provide recent medical certificates to ensure that they're in good health in order to continue on with their RARC continuation. For clarity as well, we're also specifying that the RARC continuation is based on a children of the marriage union and not another child with another individual. So children that are not born to the union would not be allowed to be used as a means to qualify for the continuation. There's some expanded grounds for revocation of PR and RARC. So this goes along with the provisions of the social inquiry and those things to happen. Individuals may have their PR revoked if they fail to support, if the marriage or civil partnership is deemed to be a marriage of a civil partnership of convenience, if the RARC ends before 7 years, the RARC is revoked. If it's now between 7 and the 15 years under which PR and RARC are being instituted for, then there's some discretion to be weighed in as to whether or not that continuation happens. Opportunity to reapply has to happen within 3 months of the revocation. This is a provision, an amendment to Section 40 of the law, adding some discretion to the Cayman Status and Permanent Residency Board and the Director of Work in relation to having some discretion around marriages that come to an end in cases where, for example, there have been severe abuse within the relationship, and the courts have looked at those situations and said that the fact that there's no current discretion in the law is not in keeping with natural justice and those other types of facilities. Therefore, some discretion has been introduced so that the board can weigh in and have some discretion around whether or not between that 7 and 15 years an individual would be able to keep their facility. Changes to Cayman status. This is in relation to persons and how long they have to hold Cayman status, hold RARC or in PR before they're able to apply for Cayman status. So currently, individuals with PR can apply at year 15 for right to be Cayman if they're naturalized, and they have 15 years in country. That's being extended to 20 years. So if you apply for your open-ended PR certificate at year 15, you can then be naturalized you then have an additional 5 years to remain in country before you can apply for the right to be Caymanian. So the runway is being extended by an additional 5 years. In relation to BOTC citizens with connectivity to another OT. So for example, if we had a person here working who was a British Overseas Territory citizen from Bermuda, that individual cannot be naturalized as a BOTC citizen for the Cayman Islands. So this provision takes into consideration that legal quandary that we have in relation to no multiple naturalizations and allow them to apply having satisfied permanent residency and so on after 20 years without having to have a Cayman Islands naturalization because they're already a BOTC citizen. It's a bit of a technical one, that one. And currently persons who are in a civil partnership or married to a Caymanian can apply for the right to be Caymanian without being naturalized at year 7. This legislation increases that to year 15. Confirmation of Caymanian status. This is a particularly vexing situation for Caymanians who are Caymanians by generational means, by descent, in that they have no means to prove that they are Caymanian, and it's extremely vexing for them to have to apply and present documents to the Director of Work to be acknowledged as Caymanians. So this provision doesn't completely remove that requirement to apply, but what it does is provide for a easier means of receiving that document. So you can effectively write and request that document if, for example, work has, the department has received documentation from you. For example, if you got your children acknowledged to enter the government school system or to apply for a government contract, or if indeed your spouse is non-Caymanian and you've applied for RARC, through that you would have supplied documents to prove that you are Caymanian. And in that case, if we have those documents, then we can just write you back and provide you with the confirmation that you are, the acknowledgement that you are indeed Caymanian. So when I checked the numbers, we were up at some 17,000, almost 18,000 acknowledgement applications within the last sort of 20 years. So a significant number of the 40%, the 40,000 Caymanians have already been dealt with through some form of acknowledgement for either themselves or somebody connected to them. Loss and revocation of Caymanian status. So currently in the Immigration Transition Act, individuals who are granted Caymanian status through the board, i.e. these are not generational Caymanians, and the word in the law that is used to define this group are those by entitlement. And I know that we use the word entitled Caymanians differently when we're referring to individuals, but in the law, and Mr. Connor gave me a bit of background on this, the entitlement came from the legal provision that says you're entitled to apply for Caymanian status. You're not entitled to Caymanian status. So for those who are entitled to apply for Caymanian status and have been granted Caymanian status, if you're outside of the islands, i.e. not legal and ordinary resident, that definition is actually in the law, then your Caymanian status could be revoked by because of that absence. And before the anxiety level goes up, there are some provisions within that have carve-outs for education, post-qualification education, working after education, medical treatment, and so on. And by way of connection, I'll also highlight that the current law has that same provision, not only for the children who have continuation of entitlement after the age of 18, but for the parents as well. So parents, I'll walk you through a scenario that may help to shed light. So a couple on work permit has a child in the Cayman Islands. That child is born to work permit holders. They progress on to have PR. They can add the child as a dependent on PR. If they acquire right to be Caymanian through grant before the child reaches 18, the child can apply to be a Caymanian through the parents for someone under the age of 18 as a dependent. At age 18, the child loses that dependent status because they're now an adult and would have to apply to keep their right to be Cayman after the age of 18. It's called continuation regularly. If that individual goes away to university for 4 or 5 years and then ends up working abroad or living abroad, not legally ordinary resident in the Cayman Islands, they could lose their right to be Cayman after 7 years now. The changes in law reduces that to 5, which coincidentally matches the provision in the existing law under which their parents, should they have moved away from the Cayman Islands, would also lose their grant to be right to be Caymanian. So currently the law says parents who acquired the right to be Caymanian through grant by a board could lose it if they're away for 5 years, and children of those parents can lose it after 7. The amendment would make both of those 5. Hopefully that's clear. If not, we can take it up and answer question and answer. Financial standing, declaration requirements. The current policy from work in relation to adding dependents is $3,500 per month in income, combined income, inclusive of those who make gratuities, to add the first dependent, and then the additional dependent is $500. The change that is coming is, one, the amount will be prescribed in legislation, and the amounts of requirement threshold increases to $5,000 for the first dependent, and additional $1,000 for each additional dependent. We have seen lots of information, and if the compliance enforcement folks were here, they would stand up and clap their hands in relation to individuals whose work permit comes in with a salary of, say, $2,000 a month. When they want to add their first dependent, we get a pay slip that has the magic number of $3,500, and that amount is put forward as their base salary so that they can then qualify for that. So in order to have a strict no tolerance to those sorts of false information, we're actually upping and introducing significant financial penalties of $10,000, 1 year imprisonment, or both for submitting false information on your financial declaration for your dependent. Other key facilities. So currently, the only facility that is required to submit an annual declaration is permanent residency through the point system. So how that works is if you have qualified for PR, so for example, one of the things you've qualified for is investment in a local company or local property, and you've divested yourself of that investment, you no longer maintain the asset that has the value to qualify for the points. You could potentially lose your PR because you no longer meet the threshold for the points. So this is an annual declaration that is made on the anniversary of your PR, same time that your fees are due. But that annual declaration doesn't extend to any other facility. So the changes in annual declaration introduces annual declarations for RARC holders, persons married to or in civil partnerships with a Caymanian. Also introduces the annual declarations for some of the high net worth investment residency certificates and so on, which also then have the requirement that they maintain a certain level of investment to keep that facility. So in relation to marriage or civil partnership, the annual declaration is not requiring any information as it relates to investments and so on. You're effectively sending in the equivalent of an affidavit saying that your marriage is still intact and you still qualify for that through marriage. The penalties for false information in that are...
Penalties for, no, we don't have a penalty.
Yeah.
Just the offense.
It is an offense for not filing and grounds for revocation. And we have received feedback from others in the consultation process that we should also add the $10,000 1 year in prison for false information to this one as well. Not currently in the law, but may well be a committee stage amendment that is to be made when we get to that point. Minister spoke well about information and information sharing and collaboration. So we are minded that the information that we are going to request through the prescribed pieces in the Immigration Cayman Protection Act will be used for decision making and for enforcement and those legitimate reasons. If, for example, we wanted to share, if we were requested to share information on students who were away studying for a particular industry. So I want to start up my own AI company. I'm looking for students who are doing their first degree or master's in AI. I want the government to share that information with me. We would not be able to share that information with a third party unless we get a disclosure from the student. But we could use that information internally to make decisions on behalf of the student. So the changes are in keeping with data protection, but allows us to be able to make decisions as it relates to enforcement action and other decisions around work permit grants and so on. The point 3 on there is information sharing around linking scholarship applicants, and we were informed and reminded at an earlier stakeholder group this week that let's not forget those Caymanian parents who are parents of Caymanian children who are self-funding their children, so they're not in the scholarship database, but are students who are looking forward to coming back to the Cayman Islands and joining the workforce. So the opportunities for them to have internships, apprenticeships, and work opportunities, we see as one that can be elevated by sharing the work database. And I would quickly thank the Chamber and the HR Society for stepping forward and joining with the government and coming together on a national workforce committee, one of which first goals is to ensure that all of the students who are currently studying either locally or abroad have opportunities for internships first off during their school breaks, as early as those coming up at the end of this year and into next summer, and going forward with a proper workforce planning and long-term view of what we can do in relation to industries, and policy could then be informed by this data, not only data for what students are studying, but data in relation to where industries are expecting labor demands to grow, so that we can shape policies around scholarship grants and so on. Under Section 53 are a number of exemptions that are granted to individuals or are exempted from individuals. This exempts individuals from needing a work permit to work, or indeed in some cases exempting them from work permit requirements. Currently the law requires those to be prescribed in regulations, so you would see some of those now. If you go on the legislation.gov.ky website under immigration, you see a number of exemptions who are listed out. There are some exemptions that, if we were to list the details, would breach data protection for some Caymanian families and other persons who have gotten this facility and have their details on view. So this provision allows for Cabinet to attach requirements to exemptions that are done by Cabinet, in relation to work permit or term limit exemptions, and for the decision on the details on that decision to not be published. I'd hasten to add that the Cabinet minutes are published, so the fact that Cabinet made a decision is public knowledge, but the details of that decision would not be published in those instances where it would be harmful to a Cayman family in that regard. The public sector term limits are another section of the current Section 53 of the Immigration Transition Law, and that portion is being amended to ensure that term limits now apply to civil servants, but work permits are not required for civil servants. There are a few exemptions to this, and it's a bit technical because the Constitution has a few positions that are not considered civil servants, so they're not under the purview of the Deputy Governor and the Public Service Management Act, so are not covered by the provisions that are being made to the Public Service Management Act and the regulations to that act that would introduce term limits to civil servants through that mechanism. These include the persons employed by the Parliament Management Commission, judges and magistrates, and those individuals who are appointed by the governor under her special powers, but are not civil servants and are not bound by PSMA. So there's a bit of legal housekeeping to ensure that we would not require a judge to have a work permit once they're appointed by the judge, by the governor. Specialist caregiver and commercial farmhand certificates. So currently in law, individuals who qualify for a specialist caregiver certificate, if they satisfy the requirements of that, they are granted the specialist caregiver certificate, and that certificate is good for 5 years. This allows them to bypass the term limit prescriptions, and at the end of the 5 years or before the 5 years, if the terms are still in place, they can apply for a new certificate, which will be granted for an additional 5 years. Currently, there is no end to that process. We are seeking to introduce a maximum of 2 of those certificates, so an additional 10 years, and or maxing the certificates to age 65 for the caregiver, and that is based on the extreme difficulty that folks have of acquiring health insurance and so on once they get past the age of 65. We've also received directions to include a similar certificate for farmhands of commercial agricultural producers that would allow their skilled expert farm workers to be able to apply for a 5-year certificate to work for that said company for a 5-year period, renewable for a subsequent 5-year period if all things are still in place for them to qualify. And again, that marks it out at 65 or at 10 years. So these 2 facilities would allow individuals to stay for, under the current term limit, a maximum of 19 years before they would then hit a hard limit of having to take a break. Fines and fees. We talked a bit about some of the fines that are being introduced in relation to false information and so on, and a few more that may come by way of committee stages. But there are also some prescripts in there. Ms. Acting Director, is it safe to say that the custom work permit fee listing is almost the same length as the prescribed fees in the regulation? So we have all sorts of nuances because we have a lot of small and medium business where a work permit might be for a, and this is just an example, not calling out anyone, a janitor who may also be doing some bookkeeping as well. So it's a bookkeeper slash janitor. I've seen some for nurse slash security guard. And these all take a person to review within the Department of Work and come up with an appropriate fee to charge. So the change that we're making is that the work permit applications will be tied to the codes in the fee guide, which are in the regulation, the prescribed codes. If a fee is not in there, we will attach you to the closest fee with your agreement, or we will go back and through a formal process amend the fees and publish those, and then you can apply on that particular one. I'll hasten to say that there is a bit of work that has been started previously that we are going to restart to revamp the entire fee structure, align it more with a Caymanian version of the ISCO codes. So for those of you who are doing your own clearance of goods online now, using CBC online systems, one of the things that you have to do is find your tariff code. The tariff code is an international code that is the same for a can of beans in Cayman as is a can of beans in the US. What we're proposing is that outside of some local bits, we will be adopting a sort of standard approach to job codes going forward. But in the meantime, we're going to be using the prescriptive version of any amendments in order to change that going forward. Where do we go next? The bill is out for public consultation, and the email address for feedback is here. That email address is immigrationconsultation@gov.ky. The inbox has been quite robust. Ms. Rollins smiling here. She's one of the persons that monitor that. We are responding to those queries that come in, and because of those queries, we're also publishing on the website gov.ky/labor frequently asked questions sheet. So I would advise you to check that sheet first. If your specific question is not on there, then fire off a question to us in relation to the bill, and we will take those forward. We're not only getting questions, we're getting suggestions for recommendations. The bill is will complete the 28-day public consultation process as is required by the Constitution on the 14th of November, and it is the view of the Minister that the bill is expected to be debated in the November sitting of Parliament once that consultation period is completed. As it relates to the introduction of the precepts in the bill, there are a number of transitional provisions, and I'll take the opportunity to say that facilities such as permanent residency, which have been granted under the existing law, will continue to fly under this existing law. Applications made that are within the time frames for that applications would be considered under the existing law and not the amended law. The bill would come into force by way of commencement orders, which allows the government, the cabinet, to stagger the implementation. We know, for example, that the DG has said publicly that the civil service term limit starts on the 1st of January, so it's our expectation that that amendment to 53, Section 53 of the existing law that would allow that to happen would need to be rolled out in that format. But some of the other bits would then be time to transition, to allow for transition to happen without undue issues and to not cause the immigration attorneys to get extra funding from us by losing challenges in the court because we didn't follow the laws of natural justice and so on. So once approved in legislation, the changes would come in and assented by the governor and so on, gazetted. The changes would come in based on commencement orders. Changes to the legislation are not retroactive and do not apply for any facilities already approved. So the carve out for that would be work permit facilities would come to their natural end, in which case then the new law would apply to that. persons who have permanent residency that doesn't have a end date would continue to maintain that, but individuals who would apply for any of those facilities after the law comes into force would be that. Similarly, individuals who are already married, and depending on when you got married, some of the previous versions of the law actually apply. So when you look through the existing immigration legislation, if you're applying for the right to become married through marriage, there are categories of dates that you have to fall into. The commencement date for this particular section would then also fall into one of those dates in relation to that. And if your marriage occurs before that, it's considered under the old law. If it happens after that date, then it's under the new law. Nope. Next steps as a ministry, Minister Miles did speak about that. We are having regular meetings. I've said to folks that we have met more often with our colleagues in the Ministry of Education within the last 5 months than we have within the last year as it relates to common ground on scholarships, training and development, work permit related issues, and data around what industries are looking for what labor and what expertise down the road. Work is also, not WORK, not WORC, work is also happening with our sister agencies as well in relation to Department of Labor and Pensions. As Minister said, we are also working on amendments to those pieces of regulation, and those are being done in tandem with the changes that are proposed for this current round of immigration and the following sets of changes as well. And also working very closely with Department of Commerce and Investment in relation to trade and business licenses and so on, and our friends over at the Health Insurance Commission and the RCIPS, and of course we can't forget our colleagues over at CBC as it relates to persons who are in country or want to come into country. So this is, again, sort of sharing of information as it relates to enforcement action, more joint operations, and a stronger immigration system as a result. We know that we can't do all that we need to do without either making it smarter and easier, not only for you, but for us as well, or we have to add massive amounts of staff, and we don't have the funding to do that. So we'll continue to invest in technology and systems and ensure that we can deliver on an efficient system for all of our services that we offer. We're continuing with stakeholder engagement. The photo that is on the screen is that one, is from our Department of Labor and Pensions, folks who had a how to get to know what the labor law has in terms of responsibilities and protections and so on. And I can say that those types of engagements will continue, and we've already been given our marching orders that those types of engagements need to be broadcast. It may not be a full Department of Comms broadcast, but we would likely put that on the department or the ministry's social media, Facebook pages and so on. So that brings us to question and answer. Mr. Moderator, you got some marching orders for folks?
I do have some questions, but before I get to the questions, I'll be taking the social media questions first. Remember, there is a 2-question limit, so please be mindful that there may be others who may have questions. But Mr. Chief Officer, at the beginning of your address, you mentioned a court case. Earlier, I wasn't sure if there was a particular point you wanted to make more on that. I think the case you're referring to is Rex versus Tapa. He was sentenced today. He received 3 months for several offenses, which included fraudulent work permits, as well as having cropped images of workforce opportunity and residency employees' signatures to commit the felonies. So I wasn't sure if there was something else you wanted to make on that note. I'd give that opportunity to you now before we go to questions.
That's exactly what I was looking for, and I was hoping it was going to be more than 3 months.
Well, for those of you interested in following that story, please visit radiocayman.gov.ky for the latest updates on court proceedings. Also, before we get into questions and answers, I want to take this opportunity just to recognize some members of parliament who've joined us since we began. I see the Deputy Leader of the Opposition, the Honorable Kenneth Bryan. Thank you so much for joining, as well as his colleague, the member for Red Bay, Mr. Roy Tatum. I'd just like to put out there that as the Member of Parliament for Red Bay, if he missed this meeting, I would have had something to say. So good to see you out. We do have 2 questions from Facebook and 1 from YouTube. I'll start with the question from YouTube. Mr. Minister and Chief Officer, I think it was related to the work permit changes. The question was, do dependents have to remain for 2 years as well with an employer before they can switch, or is that only applicable to the person applying for the work permit change? I hope I got that question right.
So, and the experts who are sitting there from the Department of Work can correct me, but dependents are attached to a particular work permit. That variation to add a dependent, if they're not added at the time the application is granted, is done by the employer. So the employer would apply for the variation. So if the employee ends that certificate, the dependent status also ends because it's a part of that facility. So yes, they would in fact be subject to that work permit facility because the dependents are attached to that work permit facility.
Thank you. Just reminding our viewers, those watching online, if you do have questions, please send your questions through. There are ministry officials monitoring YouTube and Facebook, and we'd be happy to take your questions. Over on Facebook, someone asks, if you get PR before the bill passes, can you still get naturalized within a year?
Yeah, so the PRs that have been granted and that are currently being granted are without an end date, which allows that individual to apply for naturalization within 1 year of getting that facility. They're effectively free of immigration controls when they get that PR grant and then can apply for naturalization. There are other individuals who can apply as a dependent of a PR holder as well. Those applications, if done before the bill, would also proceed under the existing legislation.
I'll take one more question from Facebook before we go to the public present in the Mary Miller Hall. The question from Facebook reads, is it legal for foreigners who take the PR immigration test to sell test answers? Part 2 to the question is there any legislation to address this behavior if it is not legal or frowned upon?
Excellent question. First off, I will say that the images, at least the ones that I've seen on social media, are not those of the official test. The official test is made up of a bank of questions, and the tests are randomly generated. But the individual who posted that also posted their number, and we've been in contact with them.
I'll hold the comment till after the end. I feel like I'm going to get in trouble, and I don't want my permit to be in trouble. I'll now head to Mr. Denny Warren, who is in the audience for his question.
Good evening. So many issues, so little time. Has there been a regulatory impact assessment done regarding this bill, and is that available to the public?
Can you expand on what you mean by?
Like where you sit down and you assess each of the provisions of the bill, and you give information about what you expect to achieve by it, so that we don't end up in a situation of unintended consequences, meaning properly consider these issues?
Yeah. So as part of the process to get this bill forward, and MP Bryan is in the room, he probably has 3 or 4 versions of this bill from his time when he was in office, because that's how long we've been working on this. The approach that we took was, one, we got directions from the boards as to issues that they were encountering and areas of exploitment that they wanted to have fixed. We got feedback from the Immigration Appeals Tribunal, who reviews the decisions of the board, and they gave us a list of fixes as well. We also got feedback from the Attorney General's chambers, and you might not believe it, but we also got feedback from some immigration officers that said, you know, put me out of business, but here are some of the holes that you need to fix with the legislation as well. But I don't want to be political, but honestly, I'll leave that to the minister. But the slides that show the growth of PR and Cayman status and the issues that we've had around work permits of convenience and so on, those are the significant changes in the bill. The other ones are housekeeping in nature, legal tweaking of required changes. So yeah, we're keenly aware, and Minister, I'm not sure that you were here when he started, but the preamble laid out the political case for change. So that is definitely in the public domain. In relation to other changes, you know, we take those all as delivering on the policy mandate.
Yeah, I mean, we've also met with, I don't know, probably 70 companies. Every sector was represented. We had at least, we're now in our 7th focus group that have represented every single sector in the Cayman Islands. We wanted to stress test it with as many attorneys that we wanted, that, you know, that we needed to, accountants, HR managers. We went through just about everything, but if you're asking for a report, I don't have that report. What I have is people that are going to be doing this on a regular basis, and we wanted to ensure that it was thoughtful, that if we needed to change or make amendments to anything, we've accepted some concessions and we've pushed through it. But it has been stress tested, certainly over the last 6 months that I've been in government.
Does clause 83A7 allow for those who are employed by government, non-Caymanians who are applied by government, to essentially go on to get Cayman status?
So if you're saying if an employee of the government manages to qualify for permanent residency, if they can go on to get Cayman status?
Are they exempted from this legislation that would allow them to continue on to, without having to comply with this the principal law as would be amended by these proposals?
Yeah. So the DG debated this in the Parliament when the Parliament first met and passed this piece of legislation in relation to amendments to the Personal Management Act. The details of that will come when the regulations are published and along with that. But the understanding is that persons within the government now are able to qualify for PR, and if they satisfy the 15-year residency, can go on to right to be Cayman, and there's nothing that we have drafted here that would prevent that from happening.
So they would be obligated to satisfy the obligations of the law as would be amended by these provisions, not the existing principal law.
Yeah. So the new provisions would only apply to a civil servant who acquires PR after these new provisions come into play. If a civil servant already has PR, then they would be able to apply for the right to be Cayman at year 15, like anybody else who currently has PR. If they acquire PR after the law comes into effect, then they can apply at year 20 when everybody else applies, and all the other criteria would apply to them.
Thank you for that. I wish I had more time, but I think the regulations should be published for people to consider what they will say, because so much of immigration law is about the regulations.
Yeah.
Thank you.
Thank you so much, Mr. Warren. I'm going to go to a question from social media. As I see our next in-person question is getting ready. The question is from YouTube, and it says, what will happen to the investment by status? Very open-ended question. I am trusting that the chief officer will be able to lend some insight.
Thanks. I think I know what the question speaks to. So I'll first off say that there is no direct route to status by investment. So you can't invest to go straight into right to be Caymanian, but there are a number of PR facilities that have a pathway to naturalization and therefore a pathway to Cayman status. What will happen to them? The mandate that we have is to, so I'll first say that the amounts of those investments were set some 10, maybe 15 years ago and haven't been increased since. So the mandate that we have is to significantly adjust those numbers upwards to better reflect what high net worth actually means now.
Thank you. And I'm going to now head over to Deputy Leader of the Opposition, the Honorable Kenneth Bryan, who has a question in hall.
Thank you, Jevi. Good evening, everyone. Good evening, panel, Minister. I just want to say thank you so much for having this public meeting. It's definitely beneficial to us all to understand the way forward in respect to immigration reform. I'm going to use my two questions. First one is, can you say what the difference is with these proposals and the white paper that was presented before? You referred the fact that we were a part of much of what was there. Can you tell me what difference is between the two?
I have personally lost track of the changes because there have been so many versions of this. But I think Minister Miles has been on record to say he came and found legislation that was quite advanced, and we've tweaked it and brought it forward. So if you're looking for political kudos, I can leave him to answer that. But the short answer is, I would say a high 90% of this is stuff that was already drafted, that was waiting on the mandate to publish and bring forward.
So it was the white paper from the last administration, majority of it, 90% of it. Okay, all right, sorry. I don't want it to get political, but I think I got my answer.
So the white paper itself was a summary of the bill and didn't contain the details. So it wasn't a consultation draft of a bill. So all of the details that are in here were not in that. We do have a record of what changes we made, and we could provide that when we meet with you on Friday for your closed session meeting on the bill.
Thank you.
So if you leave it alone,
I still got my record, so I'll find it. Don't worry. Thank you so much for the answer. I do appreciate it. Didn't mean to be political. I just wanted to say that this didn't just all happen right away. The second question is, in respect to the civil servants, we've made some changes that they will be equal to that to public sector in respect to applications to rights to be Caymanians or RERC, or permanent residency. But there's some other legislation that were giving them special provisions or protected them from being able to do certain applications because they were exempt from work permit and rollover policies. For example, if a non-Caymanian civil servant was applying for PR and wasn't approved, they have to wait 9 years before they can apply for it again. Unlike in the public sector, if you apply and you're not a part of government and you are refused, you can apply for it again within 1 year. And there's a difference because civil servants were treated differently under the protections of not being exposed. So now that we have put them on equal paring to the rest of public sector, will those other pieces of legislation also be equal to that of public sector? Like, for instance, the right to be able to apply after a year or year and a half?
And I was hoping to not have to say this tonight, but that piece of work is being done under the PSMA, and we're not responsible for that. I don't know what their drafting instructions are in relation to the limitations that are in there. Suffice to say that if they are applying reapplying aside, if they're applying through this current legislation or the upcoming legislation, they have to meet all the same requirements, i.e. time and country and so on. What they have the benefit now of is that term limits don't apply, and they don't require work permits because their government contract stands in that space.
Okay, thank you very much. Appreciate it.
Thank you. While anyone else who has a question in hall makes their way to the microphone, we do have some more questions online. I think that this next question may be somewhat related to question 7 on the frequently answered questions document, which can be found at publicconsultation.gov.ky. But the question reads, will these laws be enacted retroactively?
So yeah, I think they're asking the same question multiple ways. No, so the law does not apply for anyone who has a current facility. So if you have PR and you're currently on track for a 15-year application for right to be Caymanian, you'll continue under that timeline. If you are married to Caymanian and already married, and you're on your way to year 7 where you can apply for the right to be Caymanian, you can still go ahead and make that application and it will be considered under the existing legislation. The difference that would be the annual declarations. Yeah, those kick in for everybody once the law kicks in.
Thank you.
And that doesn't apply to work permit stuff as well. The work permit, yeah.
Understood.
Yeah.
Just having a look around to see if anyone made their way to the microphone. If not, I'll head back to social media. We have a question from YouTube. It reads, what if you were on part-time employment? Do you still have to leave the island, assuming for rollover?
So read that again for me, please. I was going to ask you to explain, but it's not your question. So,
what if you were on part-time employment? Do you still have to leave the island, assuming for rollover?
if you have a work license, you have a work permit, that starts your clock ticking. Whether or not you're working 20 hours or 60 hours, you have a work permit that has a clock ticking towards your term limit. So yeah, whether or not you're part-time or not, doesn't matter. If you have a certificate, a permit, that starts the clock, and you would hit the term limit at that point.
Thank you. I see we have a member of the public with a question. Ma'am, go ahead.
Yes, good evening. In the beginning of the presentation, there was mention of the number of status grants by marriage. You didn't mention perhaps an approximation of the percentage of those that are deemed to be marriage of convenience, right? But you did mention there is some investigation into an approximate 200 cases. What are the specific criteria that you use to determine that a marriage is of convenience? That's the first question. And then the second question, I guess do that first and maybe do follow up.
Okay, so I'm not going to give away any secrets as to what we're looking for to see if a marriage of convenience, because some folks who are listening may actually be in that situation. Mm-hmm. But what I can say that the provisions for refusal and for revocation of a facility don't have to get to the same bar of a criminal conviction. Therefore, the board can make a decision based on a number of pieces of evidence that have been provided that have evidence that the individuals are. In some cases, it's fairly overt, but in others, it would have to be a reasoned decision. I would hasten to add as well that revocations have an appeals process. They can appeal that to the Immigration Appeals Tribunal. And if they don't like that answer, they can also judicially review that. And there's many attorneys who are making a good living going through that process. But the prescripts are that evidence is presented. The way that the revocations work, it's not an automatic process where the board acts without any interaction. they would actually write to the individual to say, we're mindful to revoke based on these things. Please give us your reasoning why we shouldn't take that decision. And that is taken into consideration before a decision is made. If we don't do that, then we go off to court and they overturn the decision. So I hope that helps to paint the
Okay.
picture of what that process is.
Okay, so then my follow-up connects to that. So in your process then, the objective to do that is to fulfill the definition of intact, okay?
Yes.
However you've decided to
Yeah.
define that internally, so it has to be intact, okay? So in order to do that, right, so there's a series of paperwork of application that's completed by the couple, right? Comes through the foreigner, but then obviously the Caymanian partner is part of that application process. So in the proposed reforms, what I hear is, okay, so there's an extension of time to submit that package of paperwork for application for review, because the assumption is perhaps waiting longer would reduce the incident of marriage of convenience, right? So is there also any other plans to consider other efforts that might address that in addition to just paperwork? And I say that because papers are just papers, they're not people, right? So when that package of that application goes forward, you know, there is an opportunity to conduct interviews with the person making the application to understand who they are, where they come from, why they're here, learning about their personality, as well as their Caymanian partner. Who are they, where they work, where they live. Interviews with the people who are providing references. And in my personal experience, you know, not one phone call, not one interview, not one home visit, not one following up with an employer. There wasn't any process to that, and perhaps there's some opportunity in this reform to consider efforts that that address that could help you accomplish one of your core goals, is to preserve local culture, right? Is that you want those people to be people who want to be here and committed to the community, right?
So a brilliant question. Relying on Rolna here to jog my memory, but we do have a set of regulations that will help strengthen the current provisions within immigration law as it relates to marriage officers and what requirements we put on them as they go through their pre-marriage counseling and other things, reporting requirements and so on. And I do know that we've had a draft marriage law in the wings for quite some time now. That was put forward for the new government's consideration. Minister, I'm not sure if Cabinet's made a decision on that. It's not for our ministry. But as it relates to the requirements that we can enforce through the immigration law on marriage officers, we're doing that piece of work as well. So that wouldn't be detailed in this. We're literally asking for Cabinet's approval to go do some drafting on that, but it is coming, and brilliant question for sure.
Thanks for that. Thanks for that question. Wes is right. We are taking the lead on all of it because marriage has to start from the inception as well. It can't be transactional, and that's what we've seen here. And I mean, I don't want to get into, you know, the things that exactly what Wesley talked about, keeping some of this, how we determine confidential. I don't want to get into the specifics of it, but we've also looked at the marriage law on how marriage from pastors to ministers and other marriage officers conduct those investigations. And we've made significant progress in that, and Cabinet will be bringing that forward as well, because we believe that our immigration law is only as strong as all of the other laws that surround it. So I started looking at all of it because I wanted to understand how we can make all of it stronger we know that there are going to be some bad actors in all of this. I'm not here to investigate every person's marriage or, whether someone loves each other or not. But we also have a lot of very smart marriage officers that see a lot of this stuff come in, and we need to support them better. And that's what we're doing. We're revising forms that they can report these incidences, because currently there's not a lot. There's not a lot of, not just legislation, but there's not a lot of opportunities to report this stuff. And we have a lot of this stuff. Another thing that marriage officers are going to be able to do is report when people are shopping around for marriage officers, because they may come to a marriage officer and that person knows it's a sham marriage, but then they go to another marriage officer and all of a sudden they now find an officer that will allow that. They'll be able to post those, put those reports online, and those marriage officers should be able to go online to see if there's a report that was filed on that particular couple. All of these things do not exist right now, and we have to use technology to ensure that all of these things are now not just enforced, but they're reported properly, and we can now act on a lot of it. So great question.
So before we get the data protection people all up in arms, the reporting is on a secure site for marriage officers, so it's not a publicly available website.
Good caveat. You hear a lot of questions about it. I want to get to a few questions on social media. Sir, I'll come to you in just a short moment. Question from Facebook. Why is it that the English test is being waived for only certain companies? Now, they didn't say it, but I'll pose the question.
I don't know of it being waived. We've been requested by a number of companies to waive it. I said no, because I don't believe that anyone in our country should have that exemption. We are an English-speaking country, and if you can't speak English, you shouldn't be allowed in our country to work in a work permit. So I don't know what have happened before my time. I know what I'm being asked to do now, and we have said no. There's several construction companies that have contacted work to have this stuff waived because they have specialist people coming in. If they can't pass that test, that's at least the limited thing that they should be able to do. We're not waiving anything else. So I just want to make sure that everyone is clear on that. I also want to make sure that people also have an understanding about the exemptions that Wes talked about. When somebody applies for, have gone through a number of different facilities on their work permit, and there's no more to get, they cannot renew their work permit more. People have applied in the past to have their work permits exempted based on a number of things. Like we've had a number of people from the construction arena that have said, well, I need this employee. Well, the employee isn't a specialist. So in my last 6 months, I think we may have approved maybe 1 out of, 50 or however much that we've gotten, because I don't believe that those jobs should be protected. Those jobs should be Cayman filled and prioritized, and we need to push that a lot more. So we've balanced the scale on a lot of this, including supporting our immigration department rather than overriding the things that they're doing, which 90% of it is great work.
Thank you. Another question on social media, and then we're coming to you, sir. Question from YouTube. Speaking specifically to the compliance noted in the ministry's mission, how are we addressing those who do not abide by the requirements for pension and health contributions?
So that's an interesting one. And you follow the courts, Jevi, so you would know that there's a number of employers who have been before the summary court within the last few weeks on pension related bits. Some of those cases are as old as 2 or 3 years since they've offended. The pension reform that Minister spoke about earlier is one of the things that we want to do significant work around streamlining that process and introducing some other means of dealing with those offenders. The Health Insurance Commission is the one that has the oversight for those bits. What I can say from a ministry level, we are in discussion with all of those agencies, DCI as well, in relation to sort of repeat employers who are individuals who are able to get multiple trade and business licenses. And that's a piece of work that I know Minister Miles is championing with the caucus colleagues in relation to a way forward to make the compliance bit more well-rounded and not so much focused solely on immigration. Minister, I don't know if you want to add.
Part of enforcement for the coalition government is sharing information. What has been unfortunate, and again, I'm not saying it's by anybody's fault, but what has been unfortunate is that within government, we've created lots of either embargoes on each other or silos. Our responsibility now is to communicate and to act. That's what I'm asking, and all of my colleagues have contributed to us acting better when it comes to sharing of information and putting in good policy. We cannot reform immigration in a bubble anymore. We cannot reform immigration because we don't like an individual or a person or a company or a particular sector. We have to ensure that reforms are thoughtful and we're not constantly being taken to court and sued because we've done something wrong. So a lot of what I'm doing now is tearing down the silos and having organizations share information. We've really never even had a database that everybody contributed to, and that's an investment, based on the technology that Wes showed you at the end of where we're going. We all have to start to share information to ensure that people have a clear understanding that the government is actually talking to each other, that departments are actually collaborating, that we're enforcing our laws. I've made it clear over the last 6 months, I'm not bringing in any law unless we can enforce the law. If we can't enforce the law, what's the point, right? What is the point? So our responsibility is to now move the laws closer, that our immigration department has been heavily involved in this, and we've communicated up and down the food chain. In addition to that, is to make sure that labor and pension is part of the process, so we're not overriding some of the things that they are doing. So everything that we've been doing, and I'm not saying it's 100% accurate because nothing is, but I can tell you it is darn near close that a lot of folks have come forward and are now ready to be able to sit at the table and share information so we can create the policy and the laws that we need, because going forward we have to be able to enforce it with the current people that we have. The government doesn't have an endless pit of money anymore, unfortunately. We spent it. So we have to do with what we have. I'm not giving immigration more staff. We have to do with what we have. So therefore, part of this process as well is training up people, holding ourselves accountable. And as I've said to the 80 employers that I've met with over the last 6 months, when we don't get it right, I am the first one in the line to say, we're not getting this right. We apologize and let's make it work better. That's what I believe that this should be, how we should move this forward. The Premier agrees with this approach because our government, we're not going to get all of it right, but we certainly need to make it better when we don't get it right.
Thank you. I'm now going to head to in hall for our next question.
Hello, I got 2 questions. The first one, I think in the last...
If you can just come closer to the microphone.
Sorry. In the last 7 years or 8 years, I think, the Grand Court and the Court of Appeal have both said that the decisions of the Immigration Department can be seen to be arbitrary and opaque because of the lack of policies. Is there any plans on publishing any policies anytime soon?
Yes, absolutely.
Good question.
We are relenting to the FOIs and so on. So there's a number of policies that are being published. I think the first one up is the, what's the ones with the folks who have offended? The risk register. So in the, companies who have offended, found to be in breach of the immigration legislation, been fined or otherwise, are placed in a risk register. There's a policy around that. That policy, if it's not already published, will soon be published. And
actually, sorry to interrupt you. I did an FOI about that policy 3
I
weeks ago, and it hasn't been provided to me yet.
We're going to publish it. I know you asked for it. And we've asked for resources to in-house specific expertise to help us draft policies that would stand up to attorneys, such as those that would FOI those types of documents.
The second question I have is that you're amending Section 64, which is the section which permits expatriates to change employers during the currency of a work permit.
Yes.
Effectively, what it appears to me that you're doing is that you can't do, if you resign within the first 2 years, you can't change unless there's some prescribed circumstances which you'll tell us about in due course.
Yeah.
However, if you're sacked within those 2 years, you can.
Yes. So
sorry,
we have flagged the wording,
Yeah.
which actually starts with the holder of a work permit, and realize that if it was not what was intended, so the drafting has to be amended to reflect that it's within your first 2 years in country, not whether or not you actually hold a work permit or not. So you can't not show up to work and be sacked and then jump ship because you're no longer the holder of a work permit. So we've figured that out, and that's a committee stage amendment.
Yep.
Brilliant.
Yep.
Great, thank you.
I also, just before you leave, I just want to comment and let you also know that we've recognized that immigration don't have formal policies. We are doing formal policies. We are going to be ensuring that our laws and our policies coincide. So we're paying for all of that because the goal for us is, and this is part of getting immigration to where it's efficient, to where everyone sings from the same hymn book, that whoever you call within immigration or within the ministry, we can either pull the regulation, the law, or the policy. So all of that's going to be crafted, and I know that a number of attorneys have been asking for this for a long time. The moment that I got in, I spoke to a lot of attorneys, and they said, you know, we really need to see policies going forward because it seems very haphazard. We're gonna be moving this forward. So I appreciate, because I know you're one of the attorneys that I spoke with, and I know your frustration is that very little has been consistent. So we are listening to what the public is telling us. The difference is that we're acting. I don't have time to play politics with a lot of it or any of it. We have to get the job done, and this has to be done within 2 years because we have to start to look at what changes we need to make after that. So thank you for all of your contribution over the last couple of months of chatting with me as well.
Thank you.
I want to move on to our next question, and then after you, ma'am, we're going to go back to social media questions. Only in small part because I want to see Jordan stand up just a little bit longer. But we'll get to some more social media questions, which I see are banking up on the phone. But ma'am, over to you. And while the mic is being set up, I just want to remind the public that after there are some light refreshments that we do encourage you to partake. Of course, cannot be a Caymanian meeting without food, and so that will be happening right after. But ma'am, over to you.
Good evening, everyone. 2 quick questions, but basically feedback. Michael, do you know why the AAT was established, when, and who did that?
I do not, but I don't know if any of my, do you know when it was established?
Can't remember.
I don't know, but I can only say to you, over the last 6 months, it's been a phenomenal experience in meeting with the AET on a regular basis. I'm probably one of the few ministers, if any, who've met with the AET because they've helped us draft a number of different proposals that's in the current law and strengthen our point system. So it's been a privilege to actually work with that one organization or that one tribunal.
Minister, perhaps for the benefit of the public, you or the questioner could probably clarify.
The Immigration Appeals Tribunal. Sorry.
Thank you.
You're looking at the young woman that established and implemented the Immigration Appeals Tribunal along with the late Donovan Ebanks. I also was the secretary for 5.5 years, even when I transferred to the Ministry of Education. They had to use me for 2 years until Kim Bullins could come and take over from me. One of my members are here. Her name is Mrs. Betty Barrow. That was one of my members. and Ms. Twyla Escalante was our chairman. And that happened in 2000, and I did it for 2005, late 2005 after the hurricane. One of the things that we wanted to do was to make sure that everybody coming in, if a husband got Cayman status and they wanted to have a wife and children after 18 and they wanted to apply, we wanted to make sure that we made revenue from that. As you know, the IAT, I started off charging $100. I think it's now up to $15, it may be more. It has contributed to a lot of revenue that we needed to make sure that the government can run. But I did that. Number two, Michael, you said you weren't given staff or a lot more staff. You need a lot more enforcement staff. There's a lot of companies that will not help you. There's a lot of companies that are not going to help you and want to see these changes. And your staff, the little bit that you do have in enforcement, cannot handle the quantity of people and companies that we have here. And those fines don't need to be 1,000, they need to be 100,000 for breaking laws. Pension, also all of the nasty and verbal things that they're doing to many of the Caymanian staff. Michael, it goes hand in hand. If you're not going to treat your staff well, you're not going to have good results. I have been in law firms where I have seen British lawyers cursing their staff, the F word. Where the F is this? Where the F is that? What are we doing? This is common assault. When I worked in the judicial department, I charged you for that. There were many police officers, and including people from immigration like Mr. Franz Madison, who is now our deputy governor, and many more. Indecency, insulting the decency of women, but it is in hand. So you need enforcement out there to go through many of these companies to see the laws that they're breaking, and to make sure that they're going to pay and comply. That's my three. Take care and
Thank you.
have a good evening.
Thank you so much.
Thank you.
Minister, I don't know if you wanted to respond to that. I know she referenced you much. Are you good?
Yeah.
All right. We're going to move on to some more social media questions, and then we'll come to Mr. Rivers. Question from YouTube. Was it the intended commencement? What is the intended commencement date of the amendments? I know that it will be discussed at the next parliamentary sitting in November, but it's asking what the intended commencement date for the amendment.
So I spoke about this a little earlier, so that person probably tuned in. The only one we know, assuming that the legislation passes, that will come in at the beginning of the year, would be the provisions that introduces term limits for non-Caymanian civil servants. The other ones would then be based on sufficient time for the public and the department to get ready and so on. So we haven't discussed those with the cabinet yet, but we'll be guided by the cabinet in that regard.
Thank you. And on a similar point to the commencement of the amendment, this one is about the regulations. Will the regulations be published, and will there be time to review and consult on those?
So the regulations are a matter for the cabinet. It's not a matter for the parliament. I can't speak on behalf of the minister. You can say whether or not there's some intent to have those discussed before they come into force. But regulations by nature, unless the primary legislation requires them to be passed by the parliament, are a matter for the cabinet.
And Minister, I don't know if
Yeah,
you wanted to
and
add anything.
I agree with what Wes is saying. I mean, the regulations are going to be shared. Right now, Cabinet is going to be reviewing all regulations, and once we approve them, they'll be out for public consultation as well. But,
Thank you. Two more
part
questions.
of that process is probably not until the new year. We have to get the bill across the finish line.
Thank you, Minister. Two more questions, and then Mr. Jordan, we're coming to you. Question from Facebook. What consideration has been given to churches as it relates to work permit for pastors or essential staff within churches?
Churches are nonprofits. acting director, nonprofits are nil work permit fees, but they still need to satisfy the requirements of the law unless exempted from things like advertising. So I think that is the answer. I can say that we are looking at amendments to the Labor Act that would bring nonprofits and churches into the organizations that have to comply with that, because currently they don't have to. So I hope that helps.
I hope so too. I'm sure they will comment on Facebook and let your ministry know. Question from YouTube. When does someone with Caymanian status have to make an annual declaration? Is it just people granted status through marriage, or for everyone who holds status? And will this be retroactive?
As proposed in the draft bill, it's persons who have the right to be Caymanian through marriage, and for the 7 years under which that there's a loss provision. So if the marriage ends during that 7 years currently, if that marriage falls apart, the person could lose their status through marriage. That's the period. So we wouldn't ask them to submit declarations that they're still in an intact marriage after the 7 years, but they would do it up to 7 years.
Thank you. Mr. Minister, did you want to add anything? You're good. Mr. Rivers, over to you.
Good night, Minister. Good night to you and your panel. Mr. Moderator, thank you for the prolonged suspense. Good night to everyone inside the audience here and to the wider Cayman community. I'll use my first question here and I'll save my second one for potentially later on. But in keeping with the theme of the Caymanian Protection Act, has your ministry or the wider government as a whole given strong consideration to putting provisional carve-outs in the workforce for Caymanians only? And I think it's a safe enough question to ask this, particularly in tourism, with that being a homegrown product.
You know, I mean, great question, Jordan. Every job in the Cayman Islands is for Caymanians. Every single job. The only reason why we have folks coming in for those particular jobs is when we don't have the skill set, the experience, or the qualifications. If we start to make specific carve-outs for specific jobs, and we're saying that the majority of the jobs are in our jobs, when all of them are. So my responsibility when it comes to the human capital development aspect of really where I believe our ministry needs to get to is to ensure that we have a proper plan so our young people know where those career pathways are, or where the money is that they want to actually receive for their careers. We currently don't have that. I don't want to start to get into the specifics. I want to start to get young people and our people in general to start to understand that tourism doesn't mean making a bed, serving drinks. Tourism also means the general manager. Tourism means the director. Tourism means the manager. We consistently talk about tourism as if it's the only thing that we can get is the bellhop. And we don't actually pay. And this is one of the areas that I've challenged the Cayman Tourism Association to do better on. We can't attract Caymanians to this if we're only going to talk about the glass ceiling of it. I visited 5 hotels. Minister Ruddy and I visited 5 of the top hotels on the island over the last 6 months. No Cayman general managers. The majority of staff in their upper echelon are from the expatriate community. So I'm asking, we're giving you concessions, we're giving you discounts on work permits, but there's no succession planning. How do we get our people into that industry? We run it, we owned it. And now I'm being told that Caymanians don't want to actually work in that industry. So we have to get back to saying all of the industries are ours. We allow guest workers to come in where we don't have the expertise. So it's why this collaboration with the Cayman, with education is critical. If I don't know, and Wes don't know, and Jeremy doesn't know who is actually away on scholarship, so we can start to prepare for them, we're always going to be behind the 8 ball. And I'm not doing that for 4 years. We have to know every young person, whether they're on a scholarship from the government or from the private sector, or whether it's a child that their parents are supporting them. I've asked for everyone, submit the names so I can prepare better for them in whole the private and public sector responsible, because this is not just about holding the private sector responsible. This is about holding government responsible as well. We can't have jobs going to the expatriate community when we have hundreds, and I can tell you, my last count, it was over 1,800 Caymanians that are in some sort of tertiary education, training program, or some sort of college, whether it's overseas or on island. And yet we are saying that we're short of labor for Caymanians? We're not. Every industry is ours. And I want to make sure that organizations understand this. We are allowing you to operate in our country. It's not a right, it's a privilege. Yeah?
Thank you. Minister, I wish you all the best in your endeavors. I look forward to the next 4 years with you at the helm of this. I will say this is from lived experience. Successive governments have pretty much played ball with these individuals and allowed them to do exactly the same things that you're talking about. And until they have a clear understanding that, quite to what you've just said, that it is a privilege to be in this country and you will have a succession plan in place for Caymanians, I think we're going to continue to see what we're seeing here now. So I wish you the best in your endeavor to correct that and get Caymanians back on track in leading positions in this country. Thank you.
Over the last 6 months, we've strengthened the business staffing plan, because that's one of the areas that I believe that we had a lot of deficiencies in. We're strengthening it even more, but as I came in, one of the things that we've done differently was we have enhanced people's opportunities to make better decisions. Immigration cannot be run from the Ministry of Education or the minister. It has to be run from the knowledge, the experience, the qualifications, and the people on the ground. Immigration cannot be run from me. I have to be able to support the people who are making these decisions. Too often, immigration is being run from the ministry or the minister or the premier. We can't run immigration like that anymore. So in just 6 months, the Business Staffing Plan Board have forced over many employers to create jobs or to carve out succession planning, to make donations to, just the university college alone have received over $700,000 in scholarships. Now, we're holding people accountable. When people don't comply, I've said to the board, bring them in. Let's understand what their business cases are. What are their needs? I want to be fair and equitable across the board. If we know that we need more AI professionals and we don't have that as a skill set in our country, I'm not going to jam up business because we don't have that. But we need to also make sure that there's a Caymanian or Caymanians identified to go into that. Things like real estate. We've consistently said that our people don't want to go into real estate, which I know is untrue. Why aren't we saying, and saying to real estate organizations, here's what needs to happen. You have to be able to train up Caymanians. No one have taken it on. A lot of it is because people have donated to campaigns. No one owns me. No one owns what I've accomplished. My responsibility isn't to the donors. My responsibility is to the 40,000 Caymanians that live and work in our country. Right? This is where we're going. And as I've said, even to the opposition, I'm willing to work across the board with anyone who wants to work in the betterment of our people. Let's put the politics aside. How do we get there? How do I say to a child at Georgetown Primary School, Red Bay Primary School, the Lighthouse School, that you have a future in our country? If we don't start now, we're never going to get there. And this is why I looked at all the boards and I have said we can't play politics with this anymore. We have to put competent people on the boards and we have to hold them accountable for doing the job. I've showed you the scenario. We have 65,000 work permits. The boards are processing collectively less than 10,000 between business staffing plans, PR applications, Cayman status, work permits. It's not enough because we are too busy playing politics with this. So we have to now enhance the boards, make sure that they're doing their job, and make sure that our administrators are doing the job collectively. We can't continue to run two different immigration departments. Another thing that we have to do better at is make sure that when we do something that is not fundamentally correct, that we don't hide behind it, that we can come out and say, something we're not doing is right. We're going to do this better. The business community will have more respect for us as an organization if we can meet them halfway and say, this is not going to plan. Let's get this better. And that's what we've been doing. In the last just 3 weeks, I've met with the Cayman Islands Recruitment Association. Never heard of it. I never heard of that association until they reached out to me. I called them. We had a meeting because I wanted to meet with everyone that want to serve Caymanians. I've met with CETA. I've met with Cayman Finance. I've met with all of the accounting firms. I've met with the legal professionals. Anyone that want to meet with me in the betterment of our people, I am going to meet with. But guess what? You now have to act. Because I'm not going to sit around the table and just have conversation because you have an agenda. We have to now have a conversation that Caymanians are going to be hired, promoted, trained, and moved through your system. Because if it's not that, then this is not going to work for us anymore. I cannot promise you beyond 4 years. I'm going to promise you 4 years, and then we're going to pick up after that and move on to the next 4 years. But I can tell you in 4 years, we're going to do a lot of really great things. But the public, this is yours. This is not, immigration reform is not about Michael Miles. Immigration reform is not about Wesley Howell. Immigration reform is not about the coalition. Immigration reform is about Cayman Islands, our people, our way of life. My responsibility as a citizen of our country is to protect our way of life. Immigration reform has to be about protecting our borders, protecting our people, protecting our culture. We've only focused just on the money, on how much money we make from it. That's the small part of immigration reform. I'm focused more on the social element of it. Yeah, we can collect $100 million, but how is that used to preserve our culture, our people, our way of life? So I'm looking at immigration reform very holistically and making sure that people have an opportunity to be a part of it without an agenda, right? And that's what makes this so great, is that people are able to come here, here's what's scaring me most, we can clarify it, and then let's move on into putting it in place. What I'm not going to have are organizations coming to the table simply just to procrastinate, to stop, to prevent, because it only protects their particular agenda. We can't have that anymore. So we're moving on from this. Yeah?
Thank you so much, Minister. I am conscious of the time.
Yep.
I know that there are some snacks at the back. I do want to take this opportunity to thank our panel for joining us. I'm also conscious to the persons online that there are some questions that were not answered, but I feel it's only right that I add a little pressure, of course, with the leave of the chief officer, that the minister, I'm sure, will be able to answer those questions in the frequently asked questions section document. Again, that document can be found at publicconsultation.gov.ky. Of course, if you have any questions, any further comments, the Ministry of Caymanian Employment and Immigration want to hear from you, and please get those emails in by close of day on the 14th of November 2025. To the members of the media joining us here this evening, just to remind you that the ministry will be hosting a media roundtable for this topic, and I'm sure that that is happening, I think, later this week or next week.
Next week.
It's next week. Thank you for that. So, of course, reach out to ministry officials, and they look forward to having you. For those who are in Cayman Brac, the ministry will be traveling tomorrow to the Brac for their consultation meeting, and that will be taking place at the Lehman Scott Senior High School.
Got it right.
Did I get it right? Blame Mrs. Scott. All right. Thank you so much for joining us this evening. Please enjoy the light refreshments at the end. If you do have personal questions or very specific questions, ministry staff is on hand to answer those questions. And of course, we look forward to seeing you next time. Thank you so much.
We'll take one more.
Sorry? I'm sorry. Another question. Go right ahead.
Hello. Okay. I just wanted to ask about Section 39
which is in the current legislation, will that be in the regulation when this bill comes into force?
The current legislation.
Give us one
So
second.
Section 39 has to do with dependents of PR holders.
Uh-huh.
So will that be in the regulation for
Yes.
this bill? Or
So the way that the bill works, and this is the way that the legislation, which is why we're doing this actually, because if you're not familiar with legislation, the bill is modifying aspects of the existing legislation. So if the bill doesn't mention 39, it's not touching 39.
Okay.
So 39 stays as is, and I believe that's right. We don't have any amendments to 39, so it is still there. In some cases, we may add something to the section, and it might be a 39A, but that's not the case in this one.
Okay.
Yeah.
All right. And then the other question that I had, it had to do with Caymanians coming back.
Mm-hmm.
And the issue that a lot of Caymanians have coming back
Mm-hmm.
is that when they apply for jobs, they're being put in an intern position. And these are individuals that have associates, bachelors, and masters. So how are you going to force employers to hire Caymanians who are duly qualified in positions that they're underpaying Caymanians to be in?
That's a great question. So here's how we're making the changes to the Jobs Cayman portal and how it all connects to the business staffing plan and the business staffing plan board. I have the business staffing plan along with our ministry and our department looking now carefully at sharing that, all the data from all of those students, because currently we are now cleaning up that data from the Ministry of Education. That data, the business staffing plan board has never received that data. The business staffing plan board don't know who's overseas. So by the time those students come back, those work permits have already been granted. We need to get that done before, and that's what we're doing now. In addition to that, we also have to start to look beyond to where it's just governed by immigration. We need a suitable workforce development strategy. We need to take it off of paper, and we have to make it come alive. And that's what I'm working on now with a workforce staffing team. Because our goal now is to ensure that all of those students, and you've heard me say, I've counted over 1,800 between Cayman and overseas, that I don't know names, I don't know what they're coming back with. So we don't have an accurate labor force review on any of that. So I don't know who's coming back, who needs to go into accounting, who needs to go into HR, or who needs to go into law or whatever. We have to now address that. The business staffing plan addresses one small piece of that, but a proper human capital development plan addresses all of it. So we have to know who's coming back, and they fit right into that plan. So if Maples, for example, or Walkers, or whoever is looking for an HR person, we can say, hey, we have 5 at UCCI. You don't need to bring in anyone because you're not going to get those work permits because we have 5.
But suppose they say, oh, this person don't have the 5 years of experience to be an HR generalist. How do you justify that?
And a lot of that, as well, is that no one have actually looked into what those qualifications are, right? Because no one has ever questioned it. Like, I have organizations now coming in, being pulled into the work permit teams, and they have to answer to that. They have to answer, why does that person need 5 years, right? Why not, if you have an individual, if Wesley has 5 years, but he's an expatriate, and I have, I'm a new graduate, their responsibility, I am his successor, and they have to write a succession plan. So organizations are hiring me because I need that training. You're not gonna fast track him to PR, and then I don't get that job. It's the same as the public sector. The public sector has to do the exact same thing. So those business staffing plans, we need to actually enforce them. We actually haven't enforced them. So we have to make sure that those things are enforced. But great question.
Thank you so much.
Jebby,
And just a reminder,
Mr. Moderator, I have two cleanup bits
Go right ahead.
before you conclude. I got a little note just to give a cliff note directions to folks who are going to follow instructions and go download the bill if they hadn't already done so, and to explain a bit about how the bill works. So the bill is not replacing the existing Immigration Transition Act in its entirety. So that act will still maintain most of its sections. The bill would modify certain sections, insert some sections, and delete some sections. So what I would recommend is that when you go and download the bill, which I hope you will do, look at pages, look at all the pages, but start looking really at the reasons and objects. It goes clause by clause and explains what each clause is seeking to do. Then you actually need to go and find the old bill and the new bill and read the old act and the new bill and read each clause against that bill. If you can't do that, find us in Cayman Brack tomorrow at Lehman Scott at 6:30, and we'll be in East End on Monday at Northside Civic Center at 7 on Monday. I don't think the Northside meeting is going to be live broadcast, so you can join us. We set it at 7, so we have time to fight the traffic on the way up there. So meet us there, and if you're in Cayman Brack, or if you want to start your long weekend early, Lehman Scott tomorrow evening at 6:30. Mr. Moderator, I've taken away your job. Sorry, sir.
No, that's a good idea. Weekend in the Brack sounds like what everyone needs. Thank you again so much to everyone for joining us. Of course, remember, if you're able to join us again tomorrow in Cayman Brack and the other days that the Chief Officer mentioned, of course, stay tuned to social media on all official government social media pages, including the Ministry of Caymanian Employment and Immigration, for dates of when a meeting is coming close to you. Again, immigration consultation at gov.ky if you have any questions or comments that you want considered before the bill is finalized. Thank you again so much for joining us, and please enjoy your refreshments at the back. Thank you and have a good night.
Thank you, everyone. Be safe going home.
And you have been listening to a broadcast of the Immigration Transition Amendment Validation Bill 2025 as being discussed by the ministry at the Mary Miller Town Hall meeting tonight in Red Bay.
Yesterday,
today,
always and forever.
Radio Cayman in the Cayman Islands.
Traffic again? What in the world is going on?
Find out by tuning in to Radio Cayman's Traffic Report, brought to you 4 times daily during rush hours following the news at 7 a.m., 8 a.m., 12 noon, and 5:15 p.m. And brought to you by Subway. Need a meal on the go? Subway has 7 locations at Anderson Square, West Shore Plaza, and Industrial Park in Georgetown, Centennial Towers, West Bay, Reef Resort, East End, Countryside Shopping Village in Savannah, and in the Owen Roberts Airport Departure Lounge. No matter if you're running late, need to cater an event, or a staff meeting, Subway keeps you fueled with sandwiches, salads, pizza, wraps, and snacks. Subway, eat fresh.
Are you feeling overwhelmed, sad, stressed out, or suicidal and need support? Call 1-800-534-6463. K-Mind, Mental Health Helpline. It's okay to ask for help. K-Mind Mental Health Helpline, available from 6 p.m. to 11 p.m. Monday to Friday. It's free and confidential support and guidance on your emotional and psychological